Good evening, class. This week, for my discussion, I will be talking about the Sixth Amendment. So, the Sixth Amendment is guarantees the rights of the criminal defendants, and the rights that are covered under this amendment is the right to a speedy trial, which guarantees the due process that was established in the Fifth Amendment, and this time is established by each individual state, and if the this time period is not accomplished by the state, the case must be dismissed. The right to a lawyer, like the title explains, every defendant has the right to have a lawyer in the essence to assist him in his defense. An impartial jury, pretty much to have a jury without any bias or prejudice against the defendant, and right to know who is accusing you, providing the person that to be able to confront the person that is charging him or has evidence against his case. So there's a difference between the Fifth and the Sixth Amendment. In this case, the Sixth Amendment is more of an offense-specific amendment, while the Fifth forbids the police of questioning without an attorney, which is sort of a defensive, uh, defense-specific. The Sixth is directed towards having an attorney present during the key times of the proceeding. In contrast to the sixth, the fifth is triggered at the moment of the arrest by the reading of the Miranda rights, which are the right to remain silent, the right to counsel, and the right to have an attorney appointed over them. So the right to assistance of counsel in the Sixth Amendment, they're held by the court as uh, applicable during the critical stages of a criminal procedure, which are the arraignment, the post-indictment lineups, the post-indictment interrogation, the plea negotiations, and entering the plea of guilty. This means that an individual has the right to an attorney after being indicted and being processed by the law enforcement agency all the way through the trial, please. So the right to an attorney happens once a formal charge is given to an individual, uh, and it can begin in any of these criminal proceedings, such as the preliminary hearing, when information is given, the indictment, and the arrangement of the actual trial. In the case of a violation of the sixth, the court has had a couple of cases where they have come up with a remedy for said violation. So, according to the Supreme Court, usually the remedy for a violation is the dismissal of the case, which was established in Barker versus Wingo in 1972 and Strunk versus the U.S. in 1973. So, in Barker versus Wingo, the court affirmed that because of the factors revolving the case, the defendant had not objected to the timeline that the trial, which lasted 5 years, uh, so since he didn't waive until 3 years into the trial, uh, the court saw this as he nullified his right to a speedy trial. In the other hand, in Strunk versus the U.S., the court affirmed that the reversal of the sentence was in place because the individual was denied the right to a speedy trial in his federal offense, which lasted close to 3 years. Here are some of my references if you guys would like to hear more about them, and thank you for your time.